Imagine this. You packed up your entire life, left your family behind, followed every single rule this country set for you, paid your taxes, worked your shifts, built your career here in the United Kingdom, all because you were promised one thing: 5 years. 5 years, and you would have your indefinite leave to remain, your permanent home, your security. But now the Home Secretary is standing up and telling the whole country that 5 years is no longer enough. It is now 10. And the worst part? This does not just apply to people arriving tomorrow. It could apply to you, right now, even if you are already here, already counting down the months. This is not a rumor. This is not a proposal gathering dust on a shelf. Home Secretary Shabana Mahmood confirmed it to The Times on the 1st of March 2026. The changes are coming in autumn 2026. And if you do not know what this means for you, you need to watch this video right to the very end. Hello, and welcome back to the channel. Whether you are a skilled worker, a care worker on a family visa, or still planning your move to the UK, today's video is arguably one of the most important you will watch this year. We are breaking down the biggest change to UK immigration settlement rules in decades. We will cover exactly what is changing, who it affects, who is protected, what the migrant community is saying about it, and most critically, what you need to do right now before autumn 2026 arrives. Please do stay until the end, because the last section could genuinely change the outcome of your immigration journey. And if you find this useful, please share it with anyone you know who is living and working in the UK. This information could make a real difference to their future. To understand why this change is so significant, we first need to understand what the current system looks like. At the moment, most migrants living in the United Kingdom on a work visa or a family visa can apply for indefinite leave to remain after 5 continuous years of lawful residence. ILR, or settlement as it is also known, is essentially the UK's version of permanent residency. Once you have it, you are no longer tied to a visa. You can live, work, and study in the UK without any immigration restrictions. You can change jobs freely, you are not dependent on an employer sponsor, and after 1 further year, you can apply for British citizenship. For years, this 5-year timeline has been the cornerstone of millions of people's life plans here in the United Kingdom. That all began to shift in May 2025 when the government published its immigration white paper titled Restoring Control Over the Immigration System. Within that document, the government first floated the idea of extending the ILR qualifying period. Then, on the 20th of November 2025, the Home Office published a detailed 60-page consultation document called A Fairer Pathway to Settlement, which proposed what they called an earned settlement model. The consultation closed on the 12th of February 2026, and then on the 1st of March 2026, Home Secretary Shabana Mahmood gave a decisive interview to The Times newspaper, confirming that the government is proceeding with its plan to double the standard qualifying period for ILR from 5 years to 10 years, with the changes expected to take effect in autumn 2026. So what exactly does the new system look like? Under the proposed earned settlement framework, settlement will no longer be automatic after a fixed period. Instead, it will be based on 4 key pillars: character, contribution, integration, and residence. Let us go through each one. Under the character requirement, applicants will need a clean criminal record with no serious offenses. Under the contribution pillar, the government wants to see a clear record of national insurance payments, stable employment history, and active participation in the community. Under integration, the English language requirement is being raised from B1 to B2 level, a considerably higher standard than what is currently required. And under residence, applicants must demonstrate that they have been continuously present in the United Kingdom throughout the qualifying period. Now, here is the part that will affect the most people. The standard baseline qualifying period will be set at 10 years for most applicants. However, the system is designed to allow reductions for those who can demonstrate exceptional contributions. If your salary is $125,000 or above, you may be eligible to apply for ILR in as little as 3 years. If your salary falls between $50,000 and $125,000, a 5-year route remains available. For those on lower salaries or in lower skilled roles, the standard 10-year baseline will apply. And if someone has claimed public benefits at any point during their time in the UK, additional years can be added onto their qualifying period, which in extreme cases could push the total wait to 15, 20, or even longer. It is a dramatic departure from everything that has come before. There are some groups who will be protected from these changes. Those who already hold indefinite leave to remain are completely safe. The Home Secretary has been clear that the government will not interfere with the rights of people who have already been granted settlement. Migrants covered by the EU settlement scheme, including those with pre-settled status, are also protected. Partners of British citizens will continue to have access to a 5-year route to settlement. Global talent, visa holders, and innovator founders are expected to retain faster routes as well. And those who have resettled through official resettlement schemes will have a qualifying period of 10 years rather than the longer baselines that may apply to others. Now we come to the question that has caused the most anxiety across the entire migrant community in the United Kingdom. Will these changes apply to people who are already here? And the honest answer is almost certainly yes. The Home Secretary confirmed in her interview that the changes will apply retrospectively, meaning they will affect migrants who are already living in the UK and working towards ILR, not just those arriving after the rules change. This means that someone who arrived in 2021 who has been dutifully working, paying taxes, and expecting to apply for ILR in 2026 could now face a wait until 2031, or even beyond, depending on their individual circumstances. That is 5 additional years of visa renewals, sponsorship dependency, and immigration uncertainty. Years that were never part of the original agreement they made with this country. The reaction from the migrant community has been nothing short of extraordinary. A petition titled "Protect Legal Migrants, Do Not Implement the 10-Year ILR Proposal" gathered over 107,000 signatures. A second petition, "Keep 5-Year ILR and Restrict Access to Benefits for New ILR Holders," received more than 232,000 signatures. At the time it was debated in Westminster Hall on the 2nd of February 2026. Thousands of people have spoken out on social media, in community groups, and at public meetings, arguing that the government is moving the goalposts on people who followed the rules in good faith. Many have said they built their entire futures around the 5-year promise, their mortgage plans, their children's schooling, their career decisions, their families' lives, and that it is fundamentally unjust to change the terms after they are already here. The Migration Observatory, based at Oxford University, has also weighed in, stating that a 10-year route to settlement would make the United Kingdom more restrictive than the vast majority of other high-income countries. Critics argue that the policy does nothing to address the root causes of high migration numbers, and instead punishes the very people who followed the legal routes and contributed to British society. Legal experts, HR professionals, and employers are all raising serious concerns about the impact on workforce stability, talent retention, and the UK's ability to attract skilled international workers in the long term. There is one important lifeline worth mentioning. The government has not yet published final legislation. As of the time of this video, the 5-year rules remain in place under current immigration rules. The changes are expected in autumn 2026, but no formal statement of changes has been laid before Parliament setting the exact implementation date. This means there is still a window of opportunity, and it may be closing fast. So what should you do right now? If you are approaching 5 years of lawful residence in the United Kingdom, and you will become eligible for ILR before autumn 2026, you should speak to a qualified immigration solicitor or advisor immediately. If you can apply under the current rules before the new framework comes into force, you may be able to secure your settlement under the existing 5-year route and avoid the 10-year wait entirely. Legal professionals are strongly advising anyone in this position not to delay. The window is narrow, but it is real, and it could make an enormous difference to your future in this country. If you are further away from eligibility, you should begin building the strongest possible application file right now. That means keeping detailed records of all your national insurance contributions, your pay slips, your employment contracts, your address history, any community volunteering or public service activities, and your English language qualifications. Under the earned settlement model, every positive contribution you can document could potentially reduce your qualifying period. Getting organized now will put you in the best possible position when the rules are finalized. And if you are still outside the UK and planning to come here on a work visa, the salary threshold you target will matter enormously to your long-term settlement prospects. Higher earners will have access to faster routes, while lower paid roles will face the full 10-year baseline. It is worth factoring this into your planning before you make the move. So there you have it, a complete breakdown of the most significant change to UK immigration settlement rules in a generation. Home Secretary Shabana Mahmood has confirmed it. The consultation has closed. The retrospective application to those already in the UK has been signaled, and autumn 2026 is approaching faster than most people realize. If you are in the UK right now and working towards your ILR, please do not wait. Get advice, get your documents in order, and take action while the 5-year route is still available to you. If you found this video helpful, please share it with your friends, your family, your colleagues, anyone who is living in the UK on a visa and needs to know about this change. This is exactly the kind of information that can alter someone's entire future, and it should reach as many people as possible. Drop a comment below and let us know your situation. Are you affected by this change? How are you feeling about it? We read every single comment, and your stories matter. Do not forget to subscribe and hit the bell icon so you never miss an update like this one. We will be covering every development as this policy moves towards legislation, so stay with us. Take care of yourselves, and we will see you in the next video.